So welcome, everybody. My name is Peter Larson. I'm the chair of the Ottawa Forum on Israel-Palestine, and I'm thrilled to have as my guest today Dimitri Lascaris, who is a well-known attorney. Dimitri has been active politically for some time and is well known as a defender of human rights for Palestinians. Dimitri, thanks very much for joining me for a bit this afternoon.
Pleasure to be here, Peter. Thank you for having me.
Dimitri, I'm really happy to get your thoughts on a recent development, which was a decision by the Court of Appeal of Ontario. I may not have the terminology correct, regarding a contention between CUPW, the Canadian Union of Public Workers, and Bnai Brith Canada. And Bnai Brith, I'll give a one-line summary and you can correct me. Bnai Brith had said some things about CUPW that they found defamatory. CUPW took them to court. The court agreed with CUPW, the Postal Workers Union. Bnai Brith has appealed it, and on appeal, CUPW won and was awarded damages. Is that basically a correct summary of the thing? I missed something important.
That's partially correct. So,
okay.
First of all, you said Canadian Union of Public Workers. It's the
Postal Workers, of course. Yeah, I know that. Thank you.
And just to add a little flesh to the bones, what was specifically alleged was that the Canadian Union of Postal Workers had aligned itself with terrorism or terrorist activities because it had done some work cooperatively with the Palestinian Postal Workers Union, and Bnai Brith apparently discovered that somebody who's in some official capacity with the Palestinian Postal Workers Union had posted on his own Facebook page, not on behalf of the union itself, but on his own Facebook page, some material which suggested, according to Bnai Brith, that he supported terrorism or terrorist organizations. So Bnai Brith leapt from those facts to the conclusion or the allegation that the Canadian Union Postal Workers had aligned itself with terrorism. And so the part that you got not quite right is that this was not a final adjudication on the merits. What happened was after Bnai Brith made these allegations publicly against CUPW, they brought a defamation action, and Bnai Brith then brought a motion to dismiss that action under something called the anti-SLAPP legislation. So SLAPP is a strategic lawsuit against public participation.
That's SLAPP, is that right? Strategic lawsuit against, yeah.
And this legislation, I think, was first formulated in some states in the United States, and then it came to Ontario a few years ago. And basically, the purpose of this legislation is to get rid of lawsuits that are designed to, unmeritorious lawsuits that are designed to silence people. And it gives a defendant like Bnai Brith an opportunity to say to a court, look, don't make me go all the way to trial and incur all of the expense of defending this thing through a trial. Help me to get rid of this in a summary, inexpensive way, because this is an unmeritorious case and it's just designed to silence me. So Bnai Brith made that argument, and its argument was rejected. Basically, at first instance, there was a judge of the Ontario Superior Court of Justice who dismissed Bnai Brith's motion. Then it went up to the Court of Appeal, and the Court of Appeal affirmed the lower court's dismissal of Bnai Brith's motion. So what you now have, there's been no award of damages. That whole issue remains to be decided. What you now have is a case that will proceed to trial, subject to one other potential alternative, and that is that the Bnai Brith could appeal or seek leave to appeal the decision of the Court of Appeal to the Supreme Court of Canada. You have to get permission of the Supreme Court to do that. You don't have a right to appeal. But assuming that they don't get to the Supreme Court of Canada, now this case will proceed to trial. And at trial, a judge, after hearing live evidence, witnesses testifying under oath before him or her, will render a decision, and if decided in favor of CUPW, will then make a damages award.
Okay, so it's not finished yet. If Bnai Brith has deep enough pockets, they can go back and take it back to court, and that forces CUPW to spend a lot of time and energy basically defending its reputation. In the document that I read, Bnai Brith had said, amongst other things, that CUPW was basically calling for the murder of its own Jewish and Israeli members. It was atrocious allegation. That's based on the document that I read there. So we're not quite out of the woods, or they're not out of the woods yet. That's why it might or might not go to court. I take it depends on how much Bnai Brith wants to pursue it. Is that right?
Well, yeah, I mean, there are three possible outcomes. One, it goes all the way to trial and the judge, makes a determination after hearing all the evidence. Another is that they settle. And the third one is that they could, one side might move for summary judgment. I won't get into that. It's another procedural alternative that's available to both parties. And summary judgment is a way to decide the case before it goes to a full trial.
Okay.
So those are the three things that could happen. One thing is for sure, this case could go on for a number of years more.
I see. Okay, I had misunderstood. Thank you very much for clarifying that. Is this decision that has just been rendered, is it significant? Is it only have value for this particular case, or does it have precedent? What are the political ramifications of this?
Well, I think it is an example. I mean, if you're a Palestinian solidarity activist, wondering what all of this means, I think what you should take away from it is that when you get into a court of law in this country, and you're litigating issues around activism, defense of Palestinian rights, you are subjected to a totally different set of rules than the rules to which you are subjected when you're debating these things on social media, or you're talking to a newspaper, or somebody's publishing stuff about you on your website.
How so? Why is that different?
So, because there are rules of procedure and evidence applicable in a court of law that don't apply in the public domain. So what this basically means is you can get away with a lot of things in the court of public opinion. What I mean by that is, on social media platforms, in the press, on your website, that you will never get away with in the court of law.
Now, let me clarify. What you mean is, I hear what you're saying, but we're saying they can get away with saying stuff that they can't get away with in a court of law. Is that right? Or yeah.
Yes, absolutely. So let me give you an example of a way in which you can respond very effectively to these types of allegations in the court of law that's not available to you in the court of public opinion. Once a case like this is filed against you, a defamation action, and then you bring an anti-SLAPP motion, as Bnai Brith did, you have to defend yourself or you have to put forward on your motion, your anti-SLAPP motion, an affidavit. Some person with knowledge of the facts has to give evidence under oath. Okay, and if you say something untrue under oath, you could go to jail for perjury. Not only that, but you have to be cross-examined. You can be cross-examined on your affidavit. So, if somebody says something, some pro-Israel organization or advocate says something about me publicly, I cannot force that person to undergo interrogation under oath about what he or she said about me. But in a court of law, you can. And all of a sudden, you are now at risk. If you say something that's untrue,
they are at risk
of being charged with perjury. They are at risk, correct? Yeah. So you have to be a lot more careful about what you say in a court of law. And you are held to a much higher standard in terms of putting forward evidence to support your allegations in a court of law than you are when you're just saying nasty things about people on a website. And I think that that's why you're seeing in a case like this, and there have been other cases, there's a case we did with David Kattenberg around the labeling of settlement wines as product of Israel, where we were successful. The reason why you're seeing the Palestinian solidarity movement succeed in these environments is because there are rigorous rules of evidence that apply that don't apply in the social media context or in the press, right? So you can't get away with saying, nasty stuff about people to the same degree in a court of law as you can get away with it on your website or, when you speak to a journalist or whatever.
More that interesting distinction and helps to explain what's going on here. More broadly, I mean, do you have a sense that those people who are active in the Palestinian solidarity movement tend to, I think of the establishment, which would include the courts, as being more friendly to Israel than they are to human rights for Palestinians? Is that a correct characterization? How would you broadly characterize your interactions with the courts?
Well, let's just first of all, acknowledge the fact that judges are selected by the leaders of this country, right? And the leaders are almost invariably, I mean, it's the prime minister and his inner circle or her inner circle who are ultimately determining who sits on the bench. And, you know, all of our prime ministers in the post-World War II period have been conservatives or liberals. And, you know, they, not surprisingly, tend to put people on the bench who think like they do, right? You're not going to find too many communists or socialists sitting on the bench because the people who are appointing the judges to the bench are not communists and socialists. Sure. You know, so I think overwhelmingly the ideological disposition of people who are on the bench reflects the ideological predisposition of the leadership of the liberal and conservative parties. But it's also true that these people who are sitting on the bench are subject to a set of rules and procedure, which they take seriously, you know, about marshaling evidence, ensuring that the evidence is admissible, giving people an opportunity to question their accusers under oath and so forth. And once these procedures have been complied with, even people who are of a sort of, you know, neoliberal or conventional political disposition, all of a sudden see things differently because you are subjecting the allegations to a level of proof that they're not being subjected to in other contexts. Right. So these are intelligent people. They're thoughtful people who are sitting on the bench, even if their ideologies may not necessarily be our own. And once you get them in this environment where people are having to back up what they're saying with evidence and having to answer hard questions under oath, they all of a sudden start seeing things that they hadn't seen before.
Very interesting.
I personally feel that the Palestinian solidarity litigation we're seeing around this country has probably been an eye-opening experience for a lot of the judges because they're seeing evidence about what's being done to Palestinians that they are not typically afforded the opportunity to see just by reading the newspaper or reading some article on Bnai Brith's website.
Interesting. That's encouraging.
Yeah.
Dimitri, on this particular case, things are going to take some time to unfold. So we don't know yet where it's going to happen, but we will keep watching it. Thank you for correcting me for my misunderstanding of it and for helping us understand the news that we see before us. So thank you very much for taking the time with us today. Have a good rest of the summer.
You too, Peter.
Okay, thanks. Bye-bye.
Bye-bye.